Court does call the case of the people versus Travis Oliver.
Alexander, on behalf of the people, Your Honor.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Oliver, who stands to my right. Please state your name for the record, sir.
Travis Oliver. Thank you. All right, what do we do?
Thank you, Your Honor. There is a resolution in this matter to which Mr. Oliver will be pleading no contest as charged under a prosecutor's deferred.
And that's correct, Your Honor.
Prosecutor's deferred. Yeah, have him sworn.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, I do.
State your name.
Travis Oliver.
Sir, it is this court's understanding that you are going to be pleading no contest to the charge of malicious destruction of personal property less than $200. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You understand that?
Yes.
You understand that the fine could be increased to 3 times the value of the property destroyed or otherwise injured. If that's greater than $500, that would become the maximum fine.
Yes.
Do you understand what a no contest plea is?
Yes.
2 things about it I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest this charge. Do you understand that?
Yes.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
All right. Basis for the no contest plea, counsel?
Potential civil liability, Your Honor.
Sir, to that charge, how do you plead?
No contest.
You understand that with pleading no contest, you'll not have a trial of any kind.
Yes.
All right. You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5 on that form. Those are your rights, which are part of a trial. You understand by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
and of your own free will.
Yes.
The court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case 251258. Any objection to the court having reviewed that report?
None from the people, Your Honor.
No, Your Honor.
Based upon a review of that report and also the court having heard the testimony in this case, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of no contest to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
Second at 1 p.m.
June 2nd, 2025, 1 p.m. Defendant's bond with its condition.
Yes, sir.
Stop at probation. They're on your left-hand side. Stop in there. Get the process started. All right.
Okay. Thank you.
Thank you.
Your Honor.
Court does call the case of the people versus Stephen Grisbeck.
Alexander, on behalf of the people, Your Honor. Is Mr. Burns. Do you want to go check the hallway?
Or you could just sit there. Either way.
Today's docket is packed, from no contest pleas to bond fights and domestic violence emergencies. Watch how quickly lives change inside this courtroom. One signature, one ruling, and suddenly freedom, housing, or family access hangs in the balance. Let's break it all down.
I just saw him.
He was just back there.
Maybe he went so bad.
Like this happens every time my case gets called first.
Yes.
So, here with and on, Sam Bernstein with and on behalf of Mr. Grisbeck, who's present with me.
Your name, sir?
Stephen Grisbeck.
All right. Go ahead.
Here for sentencing, Your Honor. We were here last week when everyone very graciously and patiently listened to me ask for possible sentence where Mr. Grisbeck would do the accountable choices program in jail with release on a tether to probation afterwards. And I appreciate Ms. Pilara and Ms. Senda for listening to me, and Your Honor, of course. Mr. Grisbeck has been trying to get into that program since he got into jail, but he's been really pushing the last 2 weeks with kites and so forth. And they visited him last week and told him that there's 52 court-ordered people in line before him to get into the course, making it the most popular course in Washtenaw County on any given night. So I'm not exactly sure how that's going to play out for him, given how long it would take him to get in there. He'd be doing a significant amount of time before completion. One of the things I've been talking to him that he's concerned about is his Section 8 voucher. He's worked very hard to get it, and he's about a month away from potentially losing it, maybe a month and a half that he worked very hard to get. And he does have a job for the meantime, but we don't know how long with heating and cooling. That it's been a pretty good job for him. So he's gotten some strides going in his personal life that he stands to lose. And, I think maybe he could have held it together if he thinks accountable choices would start in the short term, but I just don't know that it is. So I guess we are asking the court to consider maybe like a release to drug treatment in the interim, to get.
How long is the program, the in-jail program?
I think it's 13 weeks, Your Honor.
Okay. Did they, did they tell you, Mr. Grisbeck, you were 52 ahead of you?
Yes, because I wrote a kite and they came back Thursday night and told me that there was 52 people ahead of me. That's with being court ordered.
Got
So
it.
there's 52 people ahead of me.
So those were 52 that had not started it yet.
I had not started it yet.
Okay. Well, I guess what I'd probably do is order this. I will, if we can find an alternative program with him out that would work for him, then I might consider release.
Your Honor, I can tell you that the program, the in-jail program, is offered out. And in my recommendation, I was asking the court to have him complete the first phase in and then continue the full programming out. So that is how.
That's how it's structured. But I guess my question is it gonna take him, does he have to wait through 52 people to do that? And
On the
then,
outside, no.
pardon?
On the outside, no.
Right,
It's
but
a 52-week program on the outside.
gotcha. But you want him to do the first phase of the DV program in jail, but he won't at best get to that. I mean, I don't know how many people are in the class, but he won't get to that at least for 13 weeks, probably much longer.
If the court is considering to release him so he can get started with that program on the outside, I would ask that he definitely have that GPS.
Quick legal pause. A no contest plea doesn't mean not guilty. It means the defendant isn't fighting the charge, and for sentencing, it's treated exactly like a guilty plea. The big difference? It can limit civil liability later. Same punishment, fewer lawsuits.
Monitor on, so he can do that.
Let's do this. So, Mr. Wilson, did you verify that it's 52 ahead of him?
I have not verified, Your Honor. Mr. Grisbeck just told me. I'm happy to, I can email Mr. Henderson who runs the program or Lieutenant Arnett.
Here's what I'll do. I'll order what's here. I need it then checked.
Okay.
as to how long it's anticipated before he would get in.
Yes.
And then I'll consider changing the program so that maybe he can complete part of that outside or complete it outside as opposed to in.
That makes sense. I appreciate that, Your Honor, and I'll send some emails right after court.
All right. Anything else you want to say before I impose that?
No, Your Honor, I don't know if Mr. Grisbeck had a couple of things he wanted to say.
I just would like to say, Your Honor, I want to take accountability for my actions, and I apologize to the courts for going through this. And I just received my Section 8 housing voucher back in November, and I just got it. And if I do any more than like a month in jail, I will lose my Section 8. And I'm just asking the courts if I could do this class, and with one, if I, I won't make no mistakes. If I do make a mistake, I have to come back and do the complete jail sentence. I'm asking for one chance. I can't show you that chance if I'm locked up, Your Honor. And I've gotten sober back in October. I've been doing these classes prior to me coming into jail. So I had been sober prior to coming to jail. And I would like to show the courts that I can not get in any more trouble, and that if I complete this class, that it'll make me even better person for today. I want to show the courts that I can do this.
All right. It's a sentence of the court. Place you on 24 months probationary term. You're to pay $555 fines and costs, 720 probation oversight fees. I'm going to make that due and payable 45 days after release.
Emails out.
There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete the in-jail DV program, phase 1, and then remainder of the program, phase 2, after release. That's what I'll order at this time. And again, I would potentially change that if necessary, once we can take a closer look at when he can get in. Continue outpatient substance abuse treatment. Follow all treatment recommendations with status reports to probation. No contact with Samantha Smith, directly or indirectly. You're not to go to the residence or employment of Samantha Smith. You're not to assault, terrorize, frighten, intimidate, threaten, harass, molest, or stalk anyone. You are not to possess weapons, firearms, ammunition, or anything fashioned to be a weapon. You're to report to probation as requested by probation, including any home visits. Begin and maintain employment with verification to probation. You are to comply with any circuit court orders. I'll set a review hearing that's to be held July 7, 2025, 1 p.m. I will order 365 days in jail. Credit 40 days served. Defendant to remain in custody until completion of the in-jail DV program. And then the balance will be suspended with placement on a GPS tether prior to release. All right.
Thank you, Your Honor.
All right. Thank you. Can you grab a phone? Court does call the case of the people versus, is it Cyan Taylor?
Allie Zend on behalf of the people, Your Honor. Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Ms. Taylor. Ms. Taylor, please state your name for the record.
Cyan Taylor.
Your Honor, we are here for a pre-trial. I'd first ask to address bond, please.
Go ahead.
Ms. Taylor is being held on a $25,000, 10% bond. She failed to appear at a final settlement conference. I am asking that the court consider reducing her bond to a personal bond. Since then, her life circumstances have changed. She's now in a more stable position, I should say. She, at that time, was essentially homeless. She's kind of bouncing around. Now she's staying with her parents, her family. Her mother is here in the courtroom. She also, at that time, wasn't working. She now has a job at Home Watch as a nurse's aide. She spoke to her mom, who spoke to that, and she will be.
Notice what just happened. the plea is accepted, but sentencing is delayed. That's for a pre-sentence investigation, where probation digs into background, employment, and history. Think of it as the court's deep dive before deciding how hard the landing will be.
Able to return to that job if released. She, at final settlement conference, the people were unable to proceed. However, because she was there or not there, the warrant was issued. I don't know if circumstances have changed with the complaining witness at this point, but our intention is to set up for final settlement conference again, depending on the bond, I suppose. But I am asking the court consider changing the bond. She's been in custody now for over a week. How many days?
A week and 3 days.
11 days now.
That she's been in.
Yes.
All right. Well, how did she come into custody?
I was at the gas station and they said they recognized me, that I had a warrant.
Well, I guess my question is, she missed the court date. Why didn't she come in at some point? Because that was back in October of last year.
Did you have a phone?
Not on, no. And also mail was going everywhere else. So it was hard keeping track of everything.
Yeah. I don't think, I think she should have gotten back in touch with us. She did mention to me just now that her, because she didn't have a stable housing situation, she wasn't getting mail, and didn't have a phone at that time. But now she does have, like I said, stable housing situation, is able to be contacted about her case.
Any response from the people?
Your Honor, I just have concerns given that this was a failed to appear last year in October and there was no contact with the defendant until she was picked up by police. I'm sure the dates are given, and I'm sure the court is, those dates are given at these hearings. She would have had notice of the dates. So I have concerns that she didn't show up until recently.
Well, how do I know you'll come back if I let you out?
I will. I don't want to be
Well, you told me it last time.
correct. I don't want to be here. I want to do better, and I'm not going to waste the court's time anymore. I just want to get back to my job, and I don't know. This was the biggest wake up call I needed, I swear.
June 9th, 2000 at 9 a.m. Set jury selection for June 9th, or June 6th is my jury final settlement coverage, correct?
Correct.
So the first date is June 6th, 2025, 9 a.m. Jury selection, June 9th, 2025, 8:30. Both of those proceedings are in-person proceedings. I'll release the defendant on a personal recognizance $25,000 bond. She needs to have a GPS tether for location tracking prior to release. Thank you. Court calls case, People versus Artist Valentine Lewis.
Alexander, on behalf of the people.
Good afternoon, Assistant Public Defender Lauren Perny on
Ma'am,
behalf.
did you understand that, what I did?
Yeah, she's gonna be on a tether at my house, right?
Right, but she may not get out right away. They've got to get her over, put a tether on her before she would then be released.
And can I say one thing real quick?
Sure.
I'm not making any excuses for her whatsoever, and she's done like a lot of mess in the last, but last Monday when she came to court, she had a full schedule starting for Tuesday. So I called her job and I let them know the circumstances, and they said that they'll, if she gets out on the 5th, that we'll get back a hold of us, and
Okay,
hopefully she can keep her job.
all right. So hopefully they can get her out get her over tethered, and she'd be out.
Do you know what time that would?
I'm not in charge of that. I don't know.
I'll find out.
Okay,
Thank you, Your Honor.
thank you. I'm sorry, Mr. Valentine, go ahead.
On behalf of Mr. Valentine Artist, Mr. Valentine Artist, please state your name for the record.
Artist Leroy Valentine Lewis.
Oh, I'm sorry, I totally butchered your name.
Yeah.
Your Honor, we're here for a show cause. Mr. Valentine owes $300 on a domestic violence case. He has been in custody for some time.
What does he owe?
Yeah, the $300 is a weird number. You did the time on.
No, it's not really, but go ahead. I don't know.
Well, it's usually if there's the case, they're much higher than $300. He did do 10 months on this case.
Well, hold on. When I issued the warrant for $75 cash. And then his bond now is 1,010%.
Yes, I saw that in JS.
Warrants fee and show cause.
Yeah, that's right. The
One
real
second.
issue. So he's got the statutory $125 fee. He's got warrant fees, which total $100. So that brings it to $225. And then $75 restitution.
I see.
When I bench warranted him back in September of 2020, I only set his bond at $75 cash because I wanted the restitution paid.
Yeah. Well,
This is where courtroom reality hits. Housing vouchers, sobriety, employment, these aren't legal buzzwords, they're survival lines. The judge isn't just weighing punishment here, she's balancing accountability against rehabilitation. One wrong call, and everything this man rebuilt disappears.
was being held on other stuff. That has all been resolved. This is now the only thing that's holding him in Washington County Jail. So I would ask this court to order him to pay the $75 when he's
Already did that. That didn't seem to work.
When he's I will say at the time he did do 10 months, right?
Yeah.
And he's been in here. How much time have you been in now?
2 weeks.
Okay. So, I don't know if you're going to work when you get out, but order him to pay that and and give him a personal bond. That's my request. I'm sorry. I'm just.
Does he have anybody that can pay the 75? Because realistically, that's what I want.
Yeah.
Because that's restitution. So if you can get somebody to pay the 75, the 125 is just there, but I'd release him.
He says he can pay the 75. You can have someone come up here and pay it as your bond.
75?
Yeah.
Not at this moment. So, I mean, if you want me to do some time on it, I could do some time on it because I got a parole hold.
No. I can't have you do time
On this.
in lieu of restitution.
Well, all right. It's kind of complicated because I got a parole hold right now for Arizona. So when I leave here, I got to go out there to finish my time out there. So I got 5 months parole left out there. So I got to finish my parole out there.
Okay, so here's what I'm asking. Is there anybody that can pay the $75 for you?
Right now, no.
At any point?
At any point, yeah. But not right now, not at this moment, though.
Define moment.
Like, when do you think you could get it paid?
As soon as I get out of here, shoot.
Yeah, but when you get out of here, you got to go to Arizona.
Yeah.
And then we're going to be right back in this boat because the 75 won't get paid.
Well,
The victim's been waiting for 5 years.
Yeah. Shit. I mean, when I get out, I'll be able to pay it when I get out. You know what I'm saying? I can't pay it right now. You feel me? Like, I gotta go take care of that, and then I'll be able to pay it. I don't even live out here, to be honest. So when I get out, I'm going back to Arizona, finish my parole, and I'll be able to pay it somehow. I ain't been out here in like 6 years, 7 years. Like, I don't even live out here.
Well, Your Honor, if are you gonna be in custody in Arizona? Or you just,
Yeah, because I just did 3 years in prison, so I gotta finish like 5 more months.
Well,
But I'm gonna be able to pay it at some time though.
yeah.
Like I'm not gonna pay it. I was incarcerated. I've been incarcerated in prison for 3 years, so I haven't been able to catch up on things. You know what I'm saying?
Yeah.
Yeah, like I just got out last August, so.
Well, given all that, Your Honor.
But he can call to get $75. That's all I'm looking for in this case.
Yeah.
I mean, the 300, the other part of that, I mean, I'll waive the $100, the other part of that. Because I get where he says that he's been in, but the statutory fee will just sit there. I just need the restitution paid.
Any family members, anything?
Yeah, I can get it paid.
All right, here's what I'm gonna do. You have him make some calls, do something, see if we can get the 75 paid. I'll adjourn it out 1 week to May 12th, 2025, 1 p.m. Let's call the case, People versus Jeremiah Driscoll.
Ally Zinn on behalf of the people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Driscoll, who should be present via Zoom. Sir, can you please unmute and state your name for the court?
Jeremiah D. Driscoll.
And Teresa Clare on behalf of probation. Your Honor, Mr. Driscoll is before the court for a review hearing. The victim is present and would like to address the court. She would like to ask that the no contact order and the no go to order be lifted. I know that she did request this from the court prior. However, the court would not consider it until Mr. Driscoll got engaged in DV programming. He is attending and compliant with that.
Personal recognizance bond with a GPS tether. That's the court saying, I'll trust you, but I'm watching. Freedom with strings attached. Miss caught again, and that trust evaporates fast. Question for you, second chance or risky gamble?
Program and compliance with his payments and reporting to probation. The victim, Kanisha Pruitt, is present. Would the court like to hear from her?
Yes, absolutely. Hello,
Hi, Judge Simpson.
what's your name?
Anisha Pruitt.
All right, what would you like to tell?
We need it lifted, the restrictions. I actually get birth in 10 weeks.
Pardon?
I get birth in 10 weeks.
10 weeks?
10 weeks. And I would like for him to be present.
You want him there?
Yeah. I don't have nobody else. I'm at work right now.
Okay.
So,
Okay. Is this your first?
no, this is my second in 17 and a half years.
Second and 17 and a half years.
Correct.
So that's like a first.
Yeah, it's like the first.
Okay. All right. You know, boy or girl, or
It's a boy.
it's a boy.
Mm-hmm.
Hope he looks like you. No, I'm just kidding. I'm just messing with you, Mr. Driscoll. All right. Do people have any objection?
Your Honor, I'll leave it in the discretion of the court.
All right. What I'm going to do, Mr. Driscoll, so that you understand, I'm going to grant the request. You understand that, sir?
Yes. Yes, Your Honor.
All right. So it's going to be a no contact. I'm going to delete that. I'm going to add a provision of no non-consensual contact, meaning that if she doesn't want you around, then you've got to leave the area. You understand that, sir?
Yes, Your Honor.
All right. Very good. All right. Thank you, man.
Thank you, Joseph.
All right. And good luck to you.
Thank you.
So I'm going to do that, change that provision. I'm going to continue all terms as previously ordered and set his next review hearing for July 14th, 2025 at 1 p.m. Without objection.
Thank you, Your Honor.
All right. Thank you.
Thank you, Mr. Driscoll. You're all
All
set.
right. Thank you, Mr. Driscoll.
All right.
Congratulations.
Thank
to
you,
you, sir.
everybody. All right. Thank you, everybody.
Court calls the case, People versus Eric Bragg.
Ally Zinn on behalf of the people.
Teresa Clare on behalf of probation. Your Honor, Mr. Bragg was scheduled before the court for a review hearing. He is fully compliant with the terms ordered by the court, and I waived his appearance. Probation's recommending the authorization. continue with the next reading hearing being set August 4th, 2025 at 1 p.m.
Hearing no objection, so ordered. Court does call the case of the people versus Clark.
Alexander, on behalf of the people, Your Honor.
Shane Clark.
And Assistant Public Defender Nicholas Bukovich on behalf of Mr. Clark, who is now approaching the podium.
Those emergency motion. Go ahead. You may proceed.
Thank you, Your Honor. The people filed this motion. I believe the defendant was arraigned on May 1st and was given a personal cognizance bond. And this was against people's request for a $25,000 cash surety with a GPS tether. People have serious concerns in this case for particularly the victim's safety, with nothing more than a PR bond in place. In this case, the victim's defendant argument, he called her a fat bitch and pulled out a knife. He was held the knife to her throat while yelling in her face, "If you interrupt me again, I'll snuff you and kill you right here." He was so close to her face while he was yelling this that spit was hitting her face. He said right before he left the car, he stated to her that once he gets his disability check, he's going to buy a .22 caliber gun and shoot her in the head. She's in fear for her life and her mother's. And she also received a text, which I believe, and for it to be read into its entirety, and it says, "You better for real stay out of my way. Don't text me unless I text you. You take my child's phone away again, I'll dismember your whole body to pieces. No cap. I'm overplaying with you. I will literally just kill you and get my life right. Free healthcare. My daughter's safe with your mom. Keep fucking playing. CUNT. I promise you don't know how real I am." And I have just extreme concerns given that he held a knife to her throat and is threatening on multiple occasions in this one case to kill her. And after the arraignment, the victim did send us a screenshot of a text, I believe from March 28th, which was before this case occurred, from the defendant, in which the message said, "Call the cops, I don't give up, I'll murder your ass the day I get out." And that was before this case. So I have concerns given that she has finally reached out to police about this defendant's behavior, what could happen to her, given that he's out on a PR bond for this, in which he threatened her life twice. Oh, probably more than twice, I believe. 3 times.
Response.
Your Honor, I'll be requesting that the court maintain the PR bond with GPS tether. Mr. Clark is currently on a GPS tether. It was addressed that day that one issue, as noted in the prosecution's bond motion, was a concern about a cell phone. Mr. Clark does have a cell phone, which he is using now for his GPS tether that is currently on his ankle. The concern was a lack of data, not him not having that device. He now has data on that cell phone. He received that. He had until Monday today, the 5th, to obtain that tether device. However, he did so within 24 hours. He was released from jail on May 1st, 2025 at 3:57 p.m. I received a call from Mr. Washington, one of the tether agents from Community Corrections at 1:22. So within that small time frame, he was able to obtain data for his cell phone and go to Community Corrections to get a tether. Mr. Clark has also been in contact with social workers, one of whom drove him here today, who are assisting him greatly in obtaining housing, which he is now on a list for those who are chronically unhoused, and hopefully should be able to obtain housing soon, and to be put on a second list as housing vouchers are now being opened again. They've also been assisting him with other matters, such as his health. He is currently suffering from liver failure and has an appointment scheduled for May 9th and one for June 14th, which at that time, his social worker will be also assisting him in getting a hotel. As noted in the emergency bond order by the prosecution, Mr. Clark has successfully been dismissed from probation in the past, showing that he can follow court orders. He does have the money to pay for the tether. He does have transport for the court. And the complaining witness, while acknowledging that this is a serious case, does reside over 30 minutes away by driving. Mr. Clark does currently rely on his social worker for transportation. Again, those, as mentioned, anything mentioned by the prosecution, it's still allegations at this point. We are not here to litigate any of the allegations here today. We are here to address bond. I do not believe there is any change in circumstances that have occurred since his arraignment that I handled last week that would warrant any changing of his bond. He is currently on a GPS tether. The court can know where he is at all times. And I believe that this bond is sufficient to protect community safety and fight.
Is the GPS just location tracking?
It's location tracking and includes an exclusion zone for the complaining witness's address. So he would not be able to get within a quarter mile of that address.
Where's the defendant residing at this point?
He is currently residing at a camp as he awaits housing.
At a camp?
Yes, he has a campsite that he resides at.
Where's the campsite?
By the Miller and Maple Park and Ride, sir.
Well, just so that we're clear, this isn't by the Maple Miller Park and Ride?
Yes, sir.
So this isn't a commercial campsite. This is just a place that you have.
That I'm holding out until I can get help, sir.
Yes, so she is part of the Pathway Housing Program. I do have a letter from that social worker here, if you'd like that, Your Honor. And Ms. Montaigne, the coordinator for that program, is in the courtroom at this time.
Pardon?
Ms. Montaigne, the coordinator for that program, is also in the courtroom. She is the one who helped Mr. Clark arrive at the court today.
The only address I have is the South Line address. Is that a correct
I
statement?
believe so, Your Honor.
How do the defendant and the alleged victim in this case, how do they know each other?
Your Honor, I believe they have been in an on and off relationship since January 2018, and they have one child together, and that his previous DV from 2021 was with this same victim.
The child who resides with mom, is that?
With her mother,
Her mother.
the victim's mother.
It's, the magistrate did order no contact with the victim's mother as well on the day of the arrest.
I see that, but so does the victim reside with the mother also?
I believe so, because it says the child attends school in South Line as well, so I believe so.
How old's the child?
They born in 2019.
The defendant's not working.
The defendant is working on getting a disability at this time due to some of his medical concerns.
Then how is he paying for the tether?
He does have some, he has shared with me, he does have some money for the tether.
Panhandle and pick up cans and do work for a lady that I know whenever she needs it. She hires me for yard work.
So how long have you been residing at the campsite that you set up?
Since last year, sir.
Are you the only one out there at that site?
Yes, sir.
Let me see, counsel in chambers, court standing back on in the record on the Clark matter. I've had an opportunity to speak with counsel in chambers, and what the court is going to do at this time, and Mr. Clark, I need you to understand what I'm going to do. I'm going to leave you on the DPS tether. I'm not going to increase any monetary bond, and that might incarcerate you. Okay, you understand that, sir?
Sure.
And then what I'm going to do is I'm going to, at this moment, increase the exclusion zone on your tether for all of South Lyon. Okay?
I understand.
And then, and I don't want it put on the record, but I'm also going to add a provision of no contact with the minor child. You understand that, sir?
Yes, sir.
All right. And then once the other part to this is that may change where I get more information regarding the victim, the alleged victim and her travels. And then I may be expanding that exclusion zone. Follow me?
Yes, sir.
All right. So that's what I'll do at this time. I think I'm going to need a new order. So I'll prepare a community corrections order with the exclusion zone is all of South Lyon. And then Ms. Zenda, if you could provide to the clerks the name, the minor child's name, and then we will be adding that to the no contact. So at this time, I guess theoretically the motion is granted. The exclusion zone will be extended to all of South Lyon, and I will add the child's name there. Anything further?
Nothing from the people, Your Honor.
Nothing from the defense, Your Honor.
All right. Thank you. Thank you, sir.